Okay, why don't we kick it off? I think we've got critical mass here. So welcome everybody to today's briefing on understanding the legal landscape around Harvard University's recent litigation with the federal government. This program is being presented jointly by Harvard Alumni for Free Speech and the Foundation on Individual Rights and Expression. I'm John Evangelakis. I'm one of the founders of Harvard Alumni for Free Speech, and I'm very glad that so many of you are joining us today for this very topical program. Harvard Alumni for Free Speech was formed several years ago by a group of alumni for the purpose of preserving and promoting free speech, academic freedom, and viewpoint diversity throughout the global Harvard-Radcliffe community. Harvard Alumni for Free Speech is a non-political, nonpartisan, and independent organization. Our members are concerned that Harvard's commitment to free speech, academic freedom, and viewpoint diversity, the core principles of liberal thought, has whittled away in recent years by intolerance and a willingness to subordinate these essential principles to other goals. As I expect you're aware, a few weeks ago, the federal government demanded that, among other things, Harvard make extensive changes to its internal governance, its hiring and admission practices, and its disciplinary practices, and also end its diversity programs. Harvard refused these demands, and as a result, the federal government suspended over $2 billion in funding to Harvard and its affiliates. Harvard subsequently sued the federal government. Our expert panel today is going to review the legal underpinning of the litigation and the dispute and provide their views on what may happen next. We've reserved some time at the end of this program for Q&A. So if you'd like to ask the panelists something, please enter your question in the Q&A box, and we will do our best to get to it at the end of the program. So let me introduce our panel members here. First, Phil Augusti, another one of the founders of Harvard Alumni for Free Speech and a former litigation partner at the Washington, D.C. firm of Steptoe and Johnson. Phil has extensive experience over 4 decades in a wide variety of litigation, including many cases involving the U.S. government. Our other panel member is Robert Shibley. Robert is the former executive director of FIRE and has extensive experience in dealing with First Amendment and due process issues on American college campuses. In addition to litigating these matters, Robert has spoken and written extensively on them, both nationally and internationally. Robert is now FIRE's special counsel for Campus Advocacy. We're very fortunate that he's able to join us today. So with that, I'm going to turn over to Phil and ask him to frame the issue and frame the conversation.
Thanks, John. As John pointed out, we at HAFFS have been really critical of the Harvard administration in the past for basically nurturing a culture that is very much anti-free speech. And I will talk as much detail as people like about the details of the litigation in response to questions. But fundamentally, our position is a policy position and a position as to the due process. We at HAFFS favor institutional neutrality and free speech. And the letter that the federal government sent to Harvard essentially seeks to not enhance free speech, but rather to replace the institution that controls speech from the university to the government. And our view really is that you need to have institutional neutrality and free speech. As John alluded to a moment ago, there were many demands in the letter to Harvard, but let me just highlight a couple. Essentially, the letter asked asked Harvard to put in place a process where the federal government would monitor the viewpoints of all of the faculty and students in every department and program at Harvard in order to achieve what in its view and the federal government's view would be a balanced viewpoint. Naturally, that's going to involve removing some faculty and students who, on the basis of their views, in order to achieve that balance. Um, the administration also took a variety of other measures that directly directly inquired about the views of individuals, including access to all Harvard files for federal government in order to be able to do its task, talked about an annual audit. These steps really are not consistent with the ideal of institutional neutrality, but rather is sort of replacing a liberal institution of compelling and forcing free speech with a conservative institution compelling and enforcing free speech. And we, at the end of the day, are for free speech. Aside from those policy perspectives, of course, this also is compelled speech, which is, plainly contrary to the First Amendment. And I would say that none of us should want a world in which every time an election happens, that the new government has an opportunity to change the viewpoint composition of the faculty and students at Harvard to meet its demands. Much of what Another point that I'd like to make is that much of what the federal government pointed to as justification for its measures was discriminations, violation of the civil rights laws. And, we, of course, believe that Harvard, like all citizens in the United States, need to comply with the civil rights laws. But the government needs to comply with the civil rights laws as well in enforcing those laws. And plainly, in this case, the detailed investigation, the detailed report laying out the allegations for the accused, and the opportunities to respond, all that are provided for in the Civil Rights Act of 1964, were plainly ignored. While we think that there may well be grounds for the federal government's objections, we believe that Harvard, like all of us, is entitled to due process. I could go on further, but I think that largely lays out the high points of our position, and I think that give Robert a chance to give Fire's view.
Great. Well, thank you for having me. It's a pleasure to be here, an honor to address the fellow alumni of my wife's institution, at least, even though I went to Duke, so not quite there, but heading in their direction. Yeah. So I like uh, like many people have been sort of watching with mixed emotions when it comes to what has been going on with the contest first between Columbia and the federal government, and now really has expanded beyond that. And of course, Harvard is next up, and of course, the biggest fish that the government is going after. And it's kind of, for those of us who've been in the reform movement for a long time, it's really kind of a good news and bad news situation. And the good news is that there is so much bad news that there is a chance for real reform that I don't think we've seen since, frankly, FIRE's founding back in 1999. One of the main reasons that FIRE was founded. And we were founded to defend First Amendment rights and due process on college campuses. And of course, we've expanded beyond just the borders of campus now, but we still keep all of our campus functions. And one of the real worries of both of our founders, Alan Kors and Harvey Silverglate, was that if we did not restore some sort of sanity to the way universities were running, they were going to use up all of their credibility and end up in a situation that is actually the very situation in which they have now ended up, which is where they no longer have, I think, a lot of the political and moral capital that was keeping them afloat in terms of public opinion and political support before this. And so, a real reason, it's important to reason, it's a good reminder that an important reason to support due process and the rule of law, even when you know the other guys are bad guys, is because eventually what goes around is going to come around. And even though it took a very long time for that to happen, I think that's what we're seeing now. So, the government, I think civil libertarians, but actually, the sort of capital L libertarians have sort of a lot to gloat about over the years. I mean, the reason that the government has so much influence over the way universities are operated is because the government has become such a huge supporter and, frankly, customer of those universities. And so, what the Trump administration seems to have figured out that many, the administrations before did not, is that universities are vulnerable in more than one way to the spigot, to having the spigot of federal funding cut off. And for those of us who've been in this, we've always thought of it as the big 800-pound gorilla being the idea that Pell Grants and Stafford loans could be cut off if you were found to have violated Title VI or Title IX. And we consider that the death penalty for universities, assuming that they couldn't stay afloat in that situation. What I think folks in the Trump administration have worked out is that for places like Harvard, the big R1 research universities that frankly make, in many cases, significantly more money. They bring in more income from their either research efforts or often, as I think is true for Harvard and a lot of places, the healthcare aspects of what they do, both of which are overwhelmingly paid for by the government, that there was this other lever that most of us hadn't really seen coming, which was the idea that the government could simply cancel its contracts with the university and put pressure on them that way. And that's what that's so far what they've been doing, and that's why it's interesting. We've never seen the involvement before now of the General Services Administration, who are the people who do government contracting in the higher ed reform space before. But now every letter you see from them has HHS and the Department of Education, and also the GSA's logos on the top of it. And they've been appealing to this idea that, hey, you know what? The government gets a lot of leeway in terms of what it can do for, actually, I think the phrase is the convenience of the government when it comes to contracts, and maybe they can just cut them off completely. And so we are actually, since this began, since the Trump administration got in, we were saying, man, this really needs to go to court, because cutting off funding to a university to this scale is actually something that has not, at least in the life of Title IX, which was from 1972, a cutoff like this has not happened. There was a debate over Grove City College, sort of a similar debate about whether or not they could take federal money, and they ultimately declined to take any federal money and still don't, in order to stay out of this sort of government crosshairs. But other than that, because it's such a severe punishment to be found, liable for having violated Title VI or IX, there are a couple of safeguards in the law for that. And one of them is what Phil was, I think, speaking about, which is there is an administrative process that Title VI, which is the law against discrimination on the basis of race, color, and national origin, and it's now generally considered, we can talk a little bit, but you would want to count anti-Semitism and, frankly, for most purposes, anything that's perceived to be kind of religious bias, although that's kind of a thorny issue. And then Title IX, which has to do with sex discrimination. That the entire process has, as far as we can tell, never been followed. And so what was supposed to happen, and what Harvard's lawsuit is, I think, correctly pointing out, and makes a very good point, that did not happen, is the way it's supposed to happen is, let's say somebody accuses you of anti-Semitism and therefore a violation of Title VI, which is, of course, what Harvard's being accused of. So the first thing that they're supposed to do, and this happens a lot, is that the Department of Education, or whatever department is providing the funding, is approaches the university and they try to get voluntary compliance with the law. So this is the only thing that generally happens, is this process of voluntary compliance. And while it's called voluntary because the universities don't actually have to agree with it, like I said, they always have. And that's because the penalty for doing so, losing all of your federal funding, is so severe. And so while it's effectively a settlement negotiation, and actually they call the Office for Civil Rights of the Department of Education, and other places they'll call them resolution letters, sometimes settlement agreements, but they're effectively legal settlements. Um, you have one side which is holding practically all of the cards, yeah, the government side. And so, for the most part, what the government says goes. However, if it gets to the point where they can't come to a voluntary resolution, even in that sense, what's supposed to happen is that they can move towards administratively cutting off funds. So they're supposed to give Harvard an opportunity for a hearing before that. You get an administrative hearing. They have to win that hearing. The government has to win that hearing, prove that discrimination was happening. Then they make an express finding on the record before they freeze financial assistance. And then they have to send a report to Congress, to the committees of the House and Senate, and give them 30 days notice before freezing federal financial assistance. And the reason for all of that is because I think people very rightly recognize that something this severe was something that was necessarily political. And so the idea was to, make sure everybody is very sure that they want this to happen before it happens. And, our thinking was always, well, let's say Ohio State or some huge university that has 60,000 students or somebody is going to lose their Pell Grants. Is Congress really going to shut down Ohio State, of all places, and throw everybody into disarray? That's a tough political sale. And so that was kind of the counterweight. Even though the government had this death penalty, it's also really unpopular to kill the people doing it. And so that sort of mutually assured deterrence was holding for a long time. And it is now seems to have been broken because the government has found this way of going after specifically these R1 institutions that they really perceive as being very hostile to the government. So that's kind of the procedural basis of what they were supposed to do. And I think from that perspective, Phil, Harvard's lawsuit is, I think, a very effective one. I think they've got a good argument that the government did ignore all of that procedure, since it hasn't happened. That's a violation of the Administrative Procedure Act, which is the act that sort of governs how these regulatory things are going to happen. And that also, particularly because President Trump hasn't made very much of a pretense out of this being some sort of neutral thing. I mean, he's talked about going after Harvard's tax exemption, taxing the endowment more, et cetera. I mean, it seems very clear that there is an amount of retaliation based on Harvard's, expressive activity that is driving this. And it is definitely an operation of chutzpah for Harvard to file the suit in some ways. As we were reading through it when it was first filed, we were thinking, this sounds like one of FIRE's lawsuits against a university, a public university, because they are citing all the same precedents about free speech and academic freedom that FIRE does. And we're saying, hey, NC State, cut it out. And, we're told to, go pound sand by the government then. And here Harvard is appealing to the same precedents and sort of learning that, yeah, there was a reason that, the government came out that way. The plus side is that Harvard is the best resourced people to be fighting this. They, we're familiar with a number of the attorneys who Harvard has hired. And, I think one of our head legal folks was saying, hey, I would have hired this guy too. So I think that it's very likely that we will get a meaningful and vigorous discussion about this. Both sides, interestingly, because the Supreme Court has not right now said that the government has to keep making payments. Um, the Both sides have agreed to an accelerated summary judgment timeline. I mean, often it can be a year or more until you get to summary judgment, but if I remember correctly, they're going to be arguing it in July. So
Yeah,
they're going to go in
July
front of not a
21.
judge, but in front of, or excuse me, not in the jury, but in front of a judge who is going to make a judgment so then it can go more quickly to the appeals process. So I think that's actually good. I think both sides will do a good job of briefing the case, but I also would expect this to at some point get to the Supreme Court. And that's because this is new. This is a novel thing. It hasn't really happened. It's not entirely clear, all the boundaries of all these doctrines. And so it's kind of an exciting time, but it's also a very scary time because, it is possible that we will find out from the Supreme Court that academic freedom doesn't mean as much as we think. Now, I actually I'm fairly confident the Supreme Court will be solid on that, but there is no guarantees in litigation. So hopefully that gives sort of a general outline.
Yeah, one thing I wanted to add that I neglected to say when I mentioned, but your comments, Robert, very much prompt, is the fact that because the tool that the government is chosen as its leverage is basically to stop grant payments, there is a possible issue as to whether this lawsuit has been filed in the right court. Basically, one of the summary judgment, I expect that the government is going to also move for summary judgment. I think the briefs are due on June 9, but I think the government will also move for summary judgment. They'll move for summary judgment because they will argue that the District of Massachusetts lacks jurisdiction because they will say that this is an issue that relates to monies coming out of a grant or a series of grants, and that therefore, under the Tucker Act, it's appropriately needs to go to the Court of Federal Claims in Washington, D.C. And of course, that would be a much less favorable court. And more importantly, it's perfectly clear that if you are litigating in the Court of Federal Claims, the government has no obligation to pay the amounts that are in dispute during the course of the litigation. So that would mean if the case were moved to the Court of Federal Claims, that would mean that basically Harvard would have to be without the funding on those grants for the duration of the litigation. So I just wanted to just mention that.
Yeah, and again, in that way, Harvard is doing everyone a service to some extent as being, the richest university, the one that is most likely to be able to withstand that and not simply accept. They're not in a position necessarily, or they're in less of a position than anybody else would be. To say, all right, you know what, we actually don't agree. We think this is going to run over our academic freedom, but we're going to settle it because otherwise the catastrophe is going to be too great. So, if it were going after a university that were less wealthy, I think there would be a lot more. I mean, even Columbia, for instance, if they were sort of the lead case in this, I think they would be under a lot more pressure to make a bad deal.
Can we pivot just for a second here? Because there's, one question that comes up a lot from people I talk to is, why are we defending Harvard? In this, right? They've been Harvard alumni for free speech. I've noted them. Fire surveyed the last 2 years. And the current leadership recognizes those problems and is trying to address them. But maybe we just kind of lay out for people, what the stakes are here. Because I mean, this procedure is great, and us lawyers love to talk about it. But why is this important for everybody?
Well, one of the things that, there is a reason that the Harvard's complaint in this looks so much like a fire complaint, and because Harvard is itself also a speaker. Institutionally, it has academic freedom, and in fact, institutional academic freedom is arguably the one that came first under American law. And the one that is the clearest is the idea that the government can't simply dictate how an institution and its constituents have to speak or do research, have to come out with these things. Um, we usually think of it in the terms of faculty and to some extent students, but the arguments are the same. Harvard is itself an institutional speaker. And so any decisions um, that start to go against the precedent that there is that academic freedom is what the Supreme Court called a special concern of the First Amendment will immediately be turned around and used on individual speakers. And it does make it tough because, yeah, I wake up some mornings, I'm like, oh, goody, I'm going to defend, the Borg or, the Empire from Star Wars here, great. But the operation of law is intended to work that way. There is intended to be one rule for everybody who's similarly situated. And to that extent, Harvard Alumni for Free Speech is situated in some important ways the exact same way Harvard University is. And so, your right to speak out on these issues does ride in large part to what Harvard's right is going to look like. But it is a very difficult argument to make because for the very reason that the academia generally has developed a deservedly bad reputation for protecting these things and for being authoritarian. It is really hard to get people out of who are not, sold on this already out of bed in the morning and say like, yeah, it'll be really bad if something bad happens to the guys who did all the bad stuff to you. I mean, that's effectively the argument you have to make. And two wrongs don't make a right. It's an important argument to make. And I think ultimately it will prevail. But popularity wise, it's kind of a loser.
Yeah, and Robert, to follow up on Robert's point, if you look at the cases upholding most of the Bill of Rights, quite frequently the defendant in those cases is a criminal.
Yeah.
So, uh, the bill usually, quite often, the people whose rights are violated are themselves criminals, and yet. Because the right is vindicated in a trial against a bad person, good people are
Well,
protected by that right.
that's a very good point. Yeah. Do we want to see? I'm
Yeah,
at the
I'm
questions.
scrolling through some of these questions here. So they've
Oh,
been
so somebody asked, do we believe Harvard has followed a policy of institutional neutrality in the past? No. I don't think anybody believes that. I think that in fact, straying so far from that is precisely part of what got Harvard and so many other schools into the crosshairs here. So, it is it hasn't gone without notice, I think, by anybody in this area that institutional neutrality has suddenly become popular in the wake of October 7th, when there became an issue on campuses that was not an easy issue to take up in terms of the milieu of people on campus. So, it's easy to say Trump is terrible or Romney is terrible or, whatever. What used to be when I was in college and law school, the idea was that the don't ask, don't tell stuff, the military was universally condemned, right? Um, and colleges were speaking out on that. They were, trying to keep people, the army, et cetera, from recruiting on campus. And so, yeah, it is telling that this is the issue. Once it got difficult, they realized how important it was to actually seem like they're a place that is safe for everybody to speak. But I mean, the University of Chicago was way out front on this years ago, and everybody would have been better off if they had use that as an example.
Just to close that off, Robert, so I think the University of Chicago adopted the Calvin Report, I
Yeah,
think, in the midst of the Vietnam War.
yeah, that's right.
So it was, I think, necessary given the divisions, in the country and I guess on that campus at the time. Up until this past year, Harvard did not actually have any kind of policy on neutrality. And I think that was one of the big problems they had in their kind of reaction to October 7th, when the leadership kept putting out these different statements, which would offend either everybody or different parties, depending on the statement. And I think they came to recognize that maybe institutional neutrality at Harvard, of course, since it's institutional voice, it's neutral voice, not institutional neutrality, but neutral voice would be a good policy. And so that was adopted this past year based on a task force recommendation. So we'll see how it's actually implemented. But yeah, there's been no pretense at Harvard of institutional neutrality in the past. So it's a new world. Maybe we can talk to some, I guess one of the questions that came in is, and this requires some speculation, and we're just kind of a legal panel, but the question is how much is the Trump administration here not actually playing for the legal win, but playing for the PR win, and just, sort of, stirring up their base of support. Seems like that's actually a perfectly legitimate question, given that they've paid, I guess, they haven't even paid lip service. They basically have disregarded all of kind of the legal formalities of, in term before even trying to suspend. But I don't know if you guys want to sort of weigh in on that.
Well, I mean, I'm not sure that I would want to speculate about, maybe Robert will take a shot at speculating on the intentions of the administration, but I will say that, currently looking at the complaint, the best issue that the administration has is that Harvard's in the wrong courtroom, because when you get to the substantive issues, I think it's fair to say that you never know what's going to happen, but certainly our feeling is that there are some constitutional violations here, that this letter really went way too far. So, there's certainly, I think, a legal basis for speculating that this wasn't a well-considered legal attack.
Yeah, I mean, if you're one of the people, and there are those people out there, and I mean, who knows if they're right or wrong on a given issue, but who are the of the Trump is playing 4D underwater chess variety and is, the galaxies ahead of us all. Um, there is a there is an argument to be had that um, the demands that they made to Harvard in this letter are different in sort of their extremity, and certainly in their immediacy, but not really in kind, to the kind of demands that have been made historically through the more deliberative process of the Department of Education and their regulations and dear colleague letters and that kinds of thing. I mean, there really is I think it would be it's not clear to what extent, I don't think it ever will be, to what extent the government's various drives for DEI or political correctness or, wokeness, whatever, its current manifestation might have been over the years, to what extent that drives what colleges do. But it is to some extent. It is to some real extent. And you see it more or less in, requirements for grants, just in general jawboning from the government. So I think there are definitely people out there, and I suspect there are people in the administration who would not be sad to see the Supreme Court um, basically rain on that entire parade and say, actually, we need to stop the whole enterprise. Like, a broad thing about saying, you know what, this is not the government's business to dictate this or that. I think there's probably a lot of people who could live with that. And so I don't know. I am not one of the 4D chess people. I think it's probably was not a good idea. So maybe I'm just overly looking on the bright side here, but there is some real clarity that could be had if this is played right as to how much of your boss is the government, really. Because having that be up in the air has led to a huge amount of government overreach over the years. And it would be nice to have some more concrete answers on that, and putting the Supreme Court in a position where they can't help but answer it. It could be really beneficial down the road, but it's going to be very tough now. And of course, it's a risky bet.
Yeah, well, I think it's been a difficult issue for the court, I guess, and going back even to
Yeah.
the Obamacare decision as to to what extent was government coercion versus government prodding. So
But
let's start another interesting question. Maybe Robert, someone asked, can you explain how pulling the funding as retaliation makes this a First Amendment issue?
Yeah, sure. So there are a couple of different doctrines that could be appealed to, but one of them is the doctrine of basically unconstitutional conditions. It's a doctrine that says effectively that the government can't use a its spending power or some collateral power, and I'm probably doing abuse to it here, but can't use something like a spending power in order to effectively require you to do things it couldn't simply require of you, on its own. So, for instance, let's say, and to give something, let's say that that Trump had come out and said, you know what, we are going to take away the tax exempt status of every university that doesn't have a sufficient number of Republicans. So I've sort of mixed two things that are going on here, right? Well, there's no doubt that freedom of association and expression say that the government couldn't simply mandate that you have some sufficient number of Republicans. So if they're going to take away a benefit from you or condition that benefit from you on doing something that they couldn't otherwise do, that itself can, be by violating the First Amendment, it would be an unconstitutional condition. I mean, the other one is there is also a doctrine of First Amendment retaliation, which is just simply that, if the government is clearly retaliating against you for speaking out on something it's not allowed to punish you for, individuals, you usually see this. We see this argument in faculty cases against state universities all the time. So, the faculty comes out and says, "Oh, I think this program is dumb," and then you get sent to the sub basement in a closet or something along those lines. Your office gets moved down there. That kind of thing that's just a doctrine of retaliation. Again, the state isn't allowed to use its coercive power in a sneaky way. It's a way to keep them from getting around that. But these are not, if you have something extremely straightforward, that's an easy one to make. But I mean, it really puts the judge in judgments here as to, at what point has the government gone too far down that road. And I think where it's going to be the biggest mess here is that the schools, they are arguing, I think Harvard is arguing correctly, that that the administration has said this is about anti-Semitism, right? They're not following the policy, but then you have, like reading through the reports and just, seeing, I think Christopher Icegroover at Princeton, the president of Princeton, like literally a couple of years ago said, like, we are an institutionally racist institution. Well, what do you do with that? I mean, so if you've admitted that you did the thing you're accused of, is it retaliation? That's where these things get really thorny. And so, any place that's big is going to have a lot of bad stuff going on. I think any place that is big, powerful, and has very little accountability is going to have even more bad stuff going on. And so I think that will be a thorny issue, is to what extent are you not allowed to go after somebody who's guilty because you're going after them for the wrong reason?
Well, and I guess to follow up on the anti-Semitism at Harvard and the recently announced anti-Semitism report, and I think Robert, you commend you. I think you've read all of it. It seems like we're way ahead of me, but I think to go back to the fact that even the lead, certainly that there's been serious issues with anti-Semitism. The leadership at Harvard admits that, but they are recognizing the issue, and they appear to be trying to taking steps here. So to go back to your your discussion on procedure, is this really the right way to deal with it? I mean, this just becomes, there's a process in the law which is supposed to protect all of us, that says, yes, if you have an issue, bring it up. We'll discuss it. We'll work out a remediation plan. And if, we don't agree with the remediation plan or you don't follow through with the remediation plan, yes, we can use this, this very devastating sanction that we have. And, I don't know, maybe you've had
Yeah,
some.
this is not the right way to go about it. I think the law, I think Harvard has the best of the argument that the law does say that if your attempt to strip funding isn't really about convenience, but it's about anti-Semitism, then you need to go through the Title VI process. So I think there is a very good argument, and I think the better of the argument is, yeah, they're supposed to go through this process. Now, I think the response that you're going to find people making, which is not as much a legal response as a prudential one, but nevertheless, one that is worth considering is that that process is very broken. Almost nobody is happy. And as long as I've been working at Fire, I can't remember a lot of people praising the Office for Civil Rights and their process, whether it's an individual who's got a complaint or these voluntary procedures, because it is a political process and people have used it to sort of grind political axes. And the department is I think it's fair to say very likely most of its civilian employees are not super big Trump fans, that process would not work properly. And that may be right, but that's still not an excuse to ignore the legally prescribed process. What it is it should be a motivation to fix that process. Right? I mean, if you have a bad process, you don't just skip it. You need to fix the process because even though, you may have it out for Harvard or something, if you are, John Doe who has really gotten a raw deal in violation of the civil rights laws from your university, like that process needs to work too. And the fact that it doesn't is actually a pretty severe moral crisis that I think has gone unaddressed through decades of this. And so, yeah, maybe it doesn't work, but that means you got to do the hard work of making it work.
Yeah, and I think the part I think should be most convincing to people is even if you agree that what the current administration is the goals they're trying to accomplish here, think of this in a future administration, one that you don't agree with the goals, and they come in and they say, hey, you've been systematically or whatever. You can pick whatever.
You'll find something, right? Yeah.
Well, because everyone's guilty of something, right? Yeah. Show me what's right. Show me the man. I'll show you the crime.
Mm-hmm.
This is tremendous power, and it can change on a dime in every election. And ultimately, we have to rely on the protection of the laws and hope applied as neutrally as possible.
Yeah,
Right?
and at the end of the day, that's really a point that you need to be thinking about when you're approving the Trump process. You may be a Trump fan and you may think that it's terrific for the federal government to be able to do this stuff, but if in the next election you have a very different president, do you really want that president to have the power to change the world without due process in the same way that this letter proposes that it be done? And I think the answer is clearly not. There has to be some stability to the way that the law is enforced.
Yeah, and we as you never want to read too much out of social media, but I think it's helpful in some ways to when Fire is out there saying, "Look, you can't do this," to the people we've been telling they can't do this, forever. And people say, "Well, you know what? It was already happening, right?" They would say like for instance, the 2013 Dear Colleague letter that sort of launched the Title IX disaster that ended up with some actually good reforms from the first Trump administration, it's a illegitimate exercise of government power. And so a lot of people at this point on the right, particularly, their thinking is like, well, what did you expect? Like this is what goes around comes around, and now it's our turn. But somebody has to obey, like somebody has to be the first one to start obeying the law, right? I mean, yes, maybe it wasn't fair before, and that means it was wrong before. It doesn't mean it's right to do the wrong thing now. But that's a very hard thing for people to get through because people are emotional about this stuff. I was speaking at the place starting with Y. I won't say its name. Just a couple weeks ago, and somebody asked, "Why are feeling so strong about this?" And I said, "I think it's because alumni and people who've been there, if they feel betrayal, right? Like they feel like it didn't have to be this way, that they were at a place that was great, it had these advantages, and yet the people running the institutions haven't maintained that. And so that their kids or grandkids can't enjoy the same sort of, open dialogue that they had. And that really does, like, people are angry about it. It is amazing to see how angry people get about this stuff. I mean, I think justifiably, to be clear, I spent my life on it, but I don't think the universities really understood or understand that fully, and that's driving a lot of this.
I'm gonna actually throw a curveball here, or at least I'm gonna relay a curveball. Number of people have asked questions about President Trump's most recent announcement this morning regarding taking away Harvard's tax-exempt status. Do either of you more the same, different? How does that enter? Does that just become another amended? Is that part of the amended complaint, or is that a totally different process?
Uh, well, I think it would be part of an amended complaint because, there are obviously laws in place that forbid a president from doing anything directly or indirectly from affecting a taxpayer status. I imagine that you may see an amended complaint at some point in the future. But, I mean, I think in terms of the the policy arguments, they're the same. I mean, essentially, it's just a bigger weapon. You're trying to compel somebody to do something, making it, as Robert pointed out a few minutes ago, trying to have an inappropriate condition on your exercise of free speech. So I think the position from a policy standpoint will be the same.
Yeah, in terms of more evidence that it's retaliatory and that this is not really some sort of concern about federal contracting and therefore just a contract case that should be in the Court of Federal Claims, but really a vendetta against Harvard. The more the president talks about that kind of thing, the more evidence he's providing on that. And so I think that suggests the fact that this maybe wasn't thought through as much as it might have been. At this point, that kind of bad news for Harvard is probably seen from, I mean, it should be seen from a litigation perspective on Harvard as good news.
Yeah,
I
very
think
much
it's
so.
hard to ignore that kind of thing, and the court won't have to. But in terms of like the tax exemption thing, that's an IRS issue that is separate from the Title VI grant issue. So they're two different
Right.
processes. And I think if I remember correctly, it was after Nixon or whatever, they put in the president isn't even allowed to, I think, officially ask the IRS to look into something. I mean, you can't really stop the president from saying somebody ought to look into this, but the IRS, I guess, is effectively prohibited from saying, "Uh-oh, that's an order from the president. We got
Right.
to do it now." So we'll see if
And
we'll see what they do.
in fact, the law was amended at that time to make clear that the director of the Internal Revenue Service is the only person that can
Oh,
direct it. So there can
okay.
be no influence whatever from any other executive agency.
No.
Well, Phil, do you know? I know about getting a 501c3 designation, but to remove a 501c3 designation, presumably there's a process, right? Presumably you get a notice that says, "Hey, we don't
Yes,
think you are," and then you have to respond, and then if there's a
and
disagreement, then you get a hearing.
exactly.
Right? So
And that process has to be completely independent of any other part of the executive branch. So
sounds like it's separate. It sounds like it's a separate complaint.
Well, yeah, I think what I was referring to an amended complaint, I was thinking like a
Yeah.
litigator in the way that Robert was, that I'd love to get that additional fact in front of the judge to show that this is a vendetta, because you do have a jurisdictional issue coming down the pike. But no, you could not litigate it. You could not litigate it in district court.
Yeah.
Basically, you'd first of all have to go through the Internal Revenue Service process.
Okay.
And then you can eventually go up to the Court of Claims.
Kind of a practical question on, I guess, like a couple of, I'd like to get your perspective on a couple of things in whatever order you want. One is, kind of lay out for us what you think is going to happen next. Wildly speculative. And all we know so far is the briefing schedule, and that there's going to be expedited. It's going to be treated in an expedited fashion. The other question is not a legal question, but this is tremendously time consuming and constraining on Harvard. And to the extent, I guess the question is, Harvard recognizes their issues. And wouldn't it be better if the federal government actually worked with Harvard to try to resolve the issues, which Harvard, I think, is actually trying to resolve, at least the current leadership is trying to resolve, rather than go through this whole the titanic struggle. So anyways, either of those questions in whatever order you want to deal with them.
Yeah, well, let me do on what's happening next. There's going to be cross motions for summary judgment that are, I believe, have to be filed by June 9, and then there's briefing. July 21 is a hearing. As I noted, I think that there's going to be a significant question about how quickly or which court you're going to be in. I think that I think that part of the reason for Harvard's decision not to seek a preliminary injunction or a TRO is that they would have a lot of trouble getting a preliminary injunction or TRO in light of the bond requirement and the requirement of showing irreparable harm. Um, so anyway, they do have in place a process that even if they get thrown into another court, can quickly be shifted into that court. So in other words, if you were to be tossed into the court of federal claims, you would then basically do the whole substantive part of this all over again in that court. So I think what's the schedule for what's going to happen really depends upon how quickly this gets up to the Supreme Court, because I really don't. I suspect that the District of Massachusetts is probably not going to, throw the case completely to another court. And it will probably be the Supreme Court when that happens. Obviously, if the Supreme Court decides that this isn't a Tucker Act issue, then it can go ahead and decide the case, and you'd have a resolution probably before the end of the year. But if it's if you go all the way up to the Supreme Court and you're in the wrong court, then you've got to start all over again. Then it may not get resolved until sometime in 2026.
So I just before Robert starts, it's just interesting. So if they agreed to a summary judgment, I guess that to me, as a non-litigator, that means no need for fact finding, no depositions,
Yeah. So
no
basically,
discovery.
there will be some discovery. Harvard has asked for the administrative record. So basically, what Harvard's strategy is that they're going to look at the administrative record, which has to be very thin on this, and then they're going to basically take the administrative record and just go on the basis of that administrative record and move for summary judgment. As I noted earlier, I think they're fairly strong on the substantive issues, just looking at it right now. I suspect that the administrative record is probably not going to be very favorable to the government. And so then they're going to put it up for the final judgment. Here is going to be at a hearing on July 21. And, the judge obviously is going to take some time to write a decision, but then you're pretty much done with the case. It's Harvard's decided, and I mean, they have very smart lawyers, as Robert pointed out earlier. They have thought through the possibility of getting shifted to the Court of Federal Claims, and so they wanted to get in place a really fast process because they know that there's a good chance that during the litigation they're not going to see any funding.
Yeah, and the fact that the government has, from what I could tell from the docket, doesn't really seem opposed to this, means that, the it's probably not going to be a hugely, there aren't going to have to be a whole ton of depositions and evidentiary stuff taken. I think part of that is because, much like what we're seeing with the immigration stuff at some point, I think there is a part of what the federal government wants to determine is to what extent do they just have the discretion to make these kinds of decisions without having to dot every I and cross every T. And of course, that's going to be, I think, very different probably in a case like this versus, an immigration case, depending on the person. But that struck me as, I guess in some ways it's well, I think in every way it's good for everyone that right now there's not a sign that they are not just trying to drag it out as long as possible to make it as expensive as possible for Harvard. And of course, they may also think that if they tried to monkey around with a timeline too much, the Supreme Court, could basically, you could skip through. The Supreme Court would say, all right, look, we can't kill every animal and every person who, needs their chemo or whatever. Like, you gotta have to, start paying the money again at some point. So it'll be good to have some resolution on that, sooner rather than later, knock on wood.
Great.
And on your second question about whether somebody ought to be negotiating, yeah,
Yeah.
I mean, basically all litigated cases can be settled. So at some point, somebody could decide that they want to settle.
Yeah, and look, I mean, there are real problems that need to be addressed, and to the extent that you could get a grand bargain going between Harvard and the government, President Trump loves bargaining. He loves deal making and stuff. I think there's probably some attraction to, you could potentially have to make a deal and say, all right, we're going to make these. We're not going to. I mean, I hope they don't say, yeah, actually, we're going to just count noses and make sure we have enough Republicans and everybody else in here. But there are probably meaningful reforms that Harvard could make. I mean, I'll say there are meaningful reforms Harvard could make that would likely be helpful. The question would be, could they sell them to the government as solving the problem? And, the other question is, of course, whether the government's really interested in solving the problem at Harvard or whether they're just using them as a punching bag.
Thank you. So I'm going to just run one really last quick question, Robert, if unfair, but let me know. Someone asked, will FIRE be filing an amicus brief in this case? And maybe the answer is you don't know yet.
Well, I'm not the person who decides that, but I think it's probably likely that we would.
Yeah. Okay, great. Okay, well, with that, we've come to the end of our hour. I apologize to everyone who asked questions we weren't able to get to. And we are going to save them, and we'll kind of I'll do our best to try to respond to outstanding questions. Thank you, Robert, and thank you, Phil. This has been an excellent and informative discussion. I also want to thank all of you out in the audience who joined us today, and I hope you found this discussion helpful in understanding what's going on between Harvard and the federal government. We at HAFFS are going to continue monitoring this situation and will provide updates as developments occur. And please also be on the lookout for other programs we'll be hosting or sponsoring regarding what's going on at Harvard. Finally, I really wanted to extend a special thank you to all of our supporters whose financial contributions have made our work, including today's program, possible. Harvard Alumni for Free Speech is a nonprofit organization, and we would not be able to do our work without generous supporters like you. So thank you, everyone, and thank you for joining us. Thank you, Robert. Thank you, Phil.
Thank you.
Thank you very much.
Bye-bye.
Bye-bye.